Diane Whitmore watched the last beam of the house at 1 Cedar Lane collapse into ash. 19 days left. She checked her watch and went home. 3 weeks later, she sat at the plaintiff's table suing the old woman who had spoken to the fire investigator. The door behind the bench opened. Marcus Reed walked in wearing a black robe. "This court recuses itself," he said. "The defendant is a witness in a case I reported." He set down the gavel and left. He never looked at her. What kind of man wins without using any power at all? 8 months before the fire on a Saturday morning in July, Marcus Reed was on his knees in his side yard replacing a fence post that had rotted through at the base. He was 52 years old, and the work took him longer than it once had. He did not mind. He had bought the house at 1 Cedar Lane 11 years earlier, when the street was still 9 ordinary houses behind an ordinary gate, and he had learned since then that most things worth keeping required maintenance nobody watched you perform. Across the street, Ruth Delaney came out with her watering can and told him the post would rot again if he didn't seal the bottom. "Then I'll seal the bottom," Marcus said, and she laughed at him the way a woman of 68 laughs at a man she has decided to look after. Ruth had lived on Cedar Lane longer than anyone. Her son Danny had a small repair business and picked up work from the Homeowners Association whenever a gutter came loose or a sprinkler head cracked, which was often enough that Ruth kept the association's newsletter on her refrigerator. She had a gray cat named Marbles, 17 years old and entirely deaf, who got out through the kitchen window at least once a week, and who could usually be found on the carport roof or down at the turnaround by the service gate, which meant that Ruth Delaney had spent more nights standing outside in her nightgown than any other person on that street. She waved at Marcus most mornings. She did not know very much about him and had never felt the need to ask. What she knew was what the street knew. He was quiet. He left before 7 and came home after 6. He wore a suit, but not an expensive one. He had a camera above his front door, which he had put up 2 years earlier after a package went missing, and which saved everything it recorded to a company server, somewhere he had never bothered to think about. He had a key fob for the service gate at the back of the cul-de-sac, same as every other homeowner, and used it maybe twice a year when the main gate stuck. And he had a filing cabinet. It stood against the back wall of his garage, gray steel, 4 drawers, each one labeled in block letters. Utilities, property, correspondence, association. Every receipt he had ever been handed, every letter he had ever received. Every notice slipped under his windshield wiper. Before he signed anything at all, a contractor's estimate, a delivery slip, a permission form he photographed at first. Then he did the second half of the habit, which nobody ever saw. That evening, the photographs came off his phone onto an external drive that lived in the second drawer of the cabinet, and once they were on the drive, he deleted them from the phone. He had started doing it his first year on the bench when the presiding judge had told a room full of new appointees that a personal device carried into a courthouse is a personal device that can be asked for, and that the wise ones kept nothing on them worth asking for. 11 years of paper existed in that garage in 2 forms, and only 2, and both of them were in the same room. Ruth teased him about the habit once watching him hold his phone over a plumber's invoice on the hood of his car. "You expecting somebody to argue with you?" Marcus slid the invoice into his folder before he answered her. "Paper doesn't lie, Miss Ruth. It just waits for the right person to read it." She thought it was a strange thing to say. She thought about it again much later and understood it differently. The Cedar Lane Homeowners Association met on the first Tuesday of the month in the community room behind the mailboxes, and Diane Whitmore ran those meetings the way other people ran companies. She was 47, she sold real estate, she lived at 3 Cedar Lane with a long white driveway that faced the mouth of the cul-de-sac, and she had been president for 6 years because nobody else wanted the job and because she was genuinely good at it. The landscaping contract she had renegotiated saved every household $400 a year. She remembered which children had graduated. When the Petersons fell behind on their dues after Bill Peterson's surgery, it was Diane who quietly moved them to a payment plan and told no one. That was the thing people missed about her. She was not a small woman with a small grievance. She was capable, and she believed her capability entitled her to outcomes. On the wall of the community room, she had hung a plat map of the street. 9 lots drawn to scale, and 8 of them shaded pale green. The 9th, the corner lot at the mouth of the cul-de-sac, was left blank white. She had put the map up in May, and no one had asked about the colors. There was always a map on that wall. After the July meeting, she sat in her car in the dark with the engine off and made a call, and her voice was not the voice she used in the community room. "I know what the deadline says," she said. "I have 8. I need 1 more. No, don't bring that up with them. I'll handle it." She listened for a while. "I said I'll handle it." The company on the other end of that call was Holloway Development, and the arrangement was simpler than anyone on Cedar Lane could have guessed. Holloway wanted the whole cul-de-sac. All 9 lots assembled into one parcel for a mixed-use build they had already sketched and already financed. Diane had brokered it. Diane had signed a preliminary agreement in her own name. Diane had taken the broker's advance against the assembly closing, and Diane, whose real estate income had been thin for 2 years, had already spent it. The agreement required 9 of 9. It named a closing date the 31st of March. She came to his door on a Sunday afternoon in August with a folder and a smile that had closed a great many deals. Marcus made her coffee. She admired the porch. She explained the offer, and it was a real offer, 20% over anything the street had seen. And she explained what it would mean for the Petersons, and for the Ackermans, and for old Mr. Doyle, whose knees would not survive another winter of those front steps. He listened to all of it. Then he told her no. She waited for the negotiation because, in her experience, no was where negotiation began. It did not come. He simply said that this was his house, that he had put in the porch himself, and that he was not looking to sell it at any price she was likely to name. There was a small silence in the kitchen, and to fill it, she asked what he did for a living. "I work at the courthouse," Marcus said. Diane nodded and said something warm about how the county was lucky to have him, and she meant it, and she also filed him away. Courthouse. Clerk, probably, or something, in records. A man on a county salary in a house he could not really afford. Being stubborn about equity, he did not know how to value. From that afternoon forward, the way she spoke to him changed. Not into cruelty, into something worse, and far more common, the patience of a person explaining a thing twice to someone she has decided is slow. He noticed. He said nothing. He photographed the offer letter, moved the image to the drive that night, and put the paper in the drawer marked property. The citation started in September. The first was for lawn height, and it was fair. He had let it go a week. The second was for a trash bin visible from the street, which it had been for one afternoon. The third was for the color of his front door, which he had not painted in 4 years. By the 3rd week of October, he had 14. Marcus did what he always did. He built a table. He pulled the association's own citation records, which any member could request, and he laid the numbers side by side. 6 weeks. 14 notices to 1 Cedar Lane. 19 notices to the other 8 houses combined. His household had been cited more than 6 times the street average by the same inspector, signed by the same president. He filed a written appeal correctly formatted, delivered by hand, requesting review by the full board. The board met and voted to deny it 4-1. The only vote in his favor came from a woman who moved away in November. He learned later that 3 of the 4 who voted against him had already been told privately what their houses might be worth in the spring. In October, someone put a long white scratch down the driver's side of his car gate to gate deep enough to catch a fingernail. He called the police. A young officer came out, took the report, and then, standing in the driveway of 1 Cedar Lane, asked Marcus whether he could show something that established he resided at the property. Marcus went inside and came back with a utility bill. The officer thanked him, wrote the report, and the report went into a system where it did what such reports do. Nothing was investigated. Nothing was assigned. It simply existed somewhere as a record that a man had complained. The third thing was Tyler. Tyler Whitmore was Diane's nephew, 24. and he did the odd jobs on Cedar Lane, that Danny Delaney's crew was too expensive for hauling pressure washing, hanging the holiday lights on the gate. He had a conviction behind him and 18 months of probation ahead of him, and his aunt had gotten him the work, and everyone on the street understood that the work was a favor. In November, he began appearing at the edge of Marcus's property, photographing the yard, standing at the fence line with a clipboard saying he was checking compliance. Once at dusk, once after dark, once at 7 in the morning while Marcus was backing out of his driveway. Marcus documented each occurrence with dates and times and petitioned for a civil restraining order. The court denied it. Insufficient basis. He read the denial twice in his car in the courthouse parking garage, and then he sat there for a while without starting the engine. It would have been easier if any of it had come with a slur. A word shouted across a lawn is a thing you can hold up. What Marcus had instead was a stack of paper in which every individual page was defensible. A citation is a citation. A vote is a vote. An officer is entitled to confirm an address. A judge is entitled to find the evidence thin. Prejudice, when it works, almost never announces itself. It operates by determining in advance whose account requires corroboration and whose does not, and the man whose account always requires corroboration will eventually be told in the politest possible language that he has failed to provide any. He had gone through every ordinary door available to a citizen in order, and every one of them had been closed with a form letter. That was the moment his approach changed. Not because he had decided to be patient, because he had run out of doors. Paula Hartley had clerked for him 9 years earlier and now practiced on her own above a dry cleaner 2 blocks from the courthouse. He brought her the whole association drawer in a banker's box. She read for 40 minutes without speaking. When she looked up, she told him he had a case someday maybe and nothing he could file tomorrow, and that in her experience the gap between those two things was where evidence went to die. She gave him 2 pieces of advice. The first was a letter. A formal notice to the association and to Brightwater Property Management. The company the association paid to run the gate, and the books demanding preservation of all records relating to 1 Cedar Lane board emails, meeting minutes, inspector assignments, key fob access logs for both the main and service gates, and all footage from the community's gate cameras. A litigation hold. Certified mail return receipt requested. They'll ignore it, Marcus said. Paula told him that was fine. The point of the letter was not that they would obey it. The point was the date on the receipt. He mailed it on the 4th of February. Her second piece of advice was practical. Given the vandalism, given the trespass, given the pattern, he should call his insurer and increase his homeowner's coverage. He did that too the same week and thought nothing of it. The letter reached Diane Whitmore on the 6th. She skimmed it. Standing at her kitchen counter, registered the phrase, preservation of electronically stored information. Decided it was a bluff, written by a cut-rate attorney for a county clerk with a grudge, and put it in the drawer where she kept warranties. She did not forward it to Brightwater. She did not need to. It had been addressed to them as well, and their compliance department had already docketed it, which is exactly the sort of thing compliance departments do without telling anyone. By then, the calendar had become a physical pressure in her chest. 53 days to the 31st of March. She called a special meeting for the 20th of February. The resolution she brought to it was 5 pages long and drafted by someone competent. It authorized a special infrastructure assessment against the corner lot at the mouth of the cul-de-sac, the only lot the resolution explained whose frontage abutted the failing drainage easement. The assessment was $40,000, payable in 30 days, secured if unpaid by a lien with power of sale. It passed. Nobody looked at Marcus while it did. He stood up in the back of the community room, and it was the first time anyone on Cedar Lane had heard him raise his voice. "I'm not selling," Marcus said, "and I'm going to keep every piece of paper you just signed." Diane held his eyes across the room and let herself smile because she had heard men make speeches before and because she was now certain of 2 things that were both entirely wrong. That he had no money, and that he had no idea how any of this worked. On the last Friday in February, Diane Whitmore sat in her attorney's office expecting to be told how quickly a lien could be turned into a sale. What she was told instead was that a judicial foreclosure in this state ran 6 to 9 months on a clean docket longer if the owner filed anything at all, and that the owner appeared to be the kind of man who filed things. She wrote 2 numbers on the pad in front of her. The assessment came due on the 22nd of March. Holloway's assembly closed on the 31st. 9 days. The legal road did not go where she needed it to go. It did not even go in that direction. So she began building a different road. It started in the neighborhood group chat, which had 206 members and no moderator. She did not post anything herself. She responded to things, which is a different and far more effective act. When a neighbor mentioned the corner house, Diane replied that she wished she could say more, but that the board had received information and she wanted to be careful. When someone asked what kind of information, she wrote that she was not comfortable speculating about anyone's history. When another neighbor asked plainly whether Marcus Reed had a record, Diane wrote that she really couldn't say. By the end of the first week of March, 3 separate households on Cedar Lane believed they had heard that Marcus Reed had been arrested for something, and none of them could have said from whom. Ruth Delaney did not believe it. Ruth said so once in the chat, and then Diane called her. The call was warm. Diane asked after Ruth's hip. She asked whether Danny's crew had gotten the invoice for the sprinkler work and mentioned that the board was reviewing all its vendor arrangements this spring, since the association would likely be looking very different by summer, and that she had always fought to keep local people on those contracts. She said she hoped Ruth understood how much she valued having someone reasonable on the street. Ruth understood. Ruth was 68 and her son had 4 employees and a truck payment. She stopped posting. She stopped waving from the porch. When she saw Marcus loading his car, she went inside, and she hated herself for it in a small, persistent way that she carried around like a stone in her shoe. The camera above his front door was turned in the night on the 7th of March. Not broken, not stolen. Turned so that it faced the porch ceiling. Marcus righted it the next morning and tightened the mount. Then he drove 40 minutes to a store where nobody knew him and bought a second camera. A small 1-battery powered and mounted it that evening inside the front window behind the curtain angled down the length of his driveway toward the street and the white driveway of 3 Cedar Lane beyond it. He told no one. He did not tell Paula Hartley, and later he would think a great deal about that decision. 2 nights after that, marbles got out again, and Ruth Delaney went down to the turnaround at 2 in the morning in her nightgown and a raincoat and found Tyler Whitmore standing at the service gate. He was not working. He was not carrying anything. He was holding his phone and looking at the back of the corner house, and when he saw her, he said good evening and walked to his truck. Ruth carried the cat home and told nobody because she had already decided that spring that she was a woman who told nobody things. By March, the fight had outgrown the 9 houses on Cedar Lane. Brightwater Property Management, which ran the gate system and kept the books, had begun sending the association carefully worded emails about documentation because Brightwater's compliance department had docketed a preservation demand in early February and had a policy about such things. Holloway's counsel called Diane twice a week now, and the calls had lost their friendliness. Assembly deals died all the time, and Holloway had lawyers whose entire function was making sure that when they died on someone else's balance sheet. A reporter for the County Weekly, a woman named Nora Chandler, started asking around about a 9-lot assemblage that had been recorded as a preliminary agreement and never closed. A city inspector came out to look at the drainage easement that the special assessment had been levied to repair and found it in acceptable condition and wrote that down in a report that nobody read for another 6 weeks. None of it moved fast enough to matter. That is the thing about institutions. They arrive eventually, and eventually is a length of time measured against the calendar of the person waiting. On the 9th of March in her kitchen with the blinds down, Diane made her nephew a plate of food and talked to him for an hour. She was not raving. That is what would have been hardest to explain afterward. She was the same woman who had renegotiated the landscaping contract and remembered everyone's children, and she spoke to Tyler in the reasonable voice of a person who has thought a problem all the way through. 8 families, she said. The Petersons are going to lose that house. You know what Bill's treatment costs. The Ackermans have a boy starting school in the fall, and they are underwater by $60,000. Mr. Doyle can't do those steps anymore, and he won't say it. 8 families are waiting, and one man who has lived here 11 years and knows none of their names has decided he'd rather be right. Tyler said that maybe the guy just liked his house. Diane set down the dish towel. Everybody likes their house. That's not a moral position, that's a preference, and I am not hurting anyone. That's what I need you to hear. I'm not hurting a single person. I am removing an obstruction. She said it again, quieter, and it sounded less like an argument than a thing she was confirming for herself. Then she said the sentence that would 11 months later be read aloud in a courtroom from a transcript. The house is empty. I'll take care of the house being empty. She believed, sitting in that kitchen, that she was not a criminal. She believed she was clearing a site. Marcus had told the whole street he would be gone. He had told them at the February meeting on the record in the minutes because he had stood up during the business portion and requested a 14-day extension on the special assessment, explaining that he would be out of state at a professional conference from the 11th through the 14th of March and would need time on his return to respond formally. The board denied the extension 5 votes to none. The seat that had been vacated in November was filled now by a man who had been shown the spring valuation figures on his second day, and there was no longer anyone in that room with a reason to abstain. The minutes recorded the denial, and they recorded the dates. He left on the morning of the 11th, a Tuesday, and drove 3 hours to a hotel in a city where he sat in a windowless ballroom for 2 days and listened to people discuss sentencing guidelines. He did not check his cameras. He had a habit of not checking them because the whole point of the cameras was that he did not have to. On the night of the 12th of March at 11:41, Diane Whitmore's phone connected to Tyler Whitmore's phone for 47 seconds. At 11:47, key fob number 224 issued to T. Whitmore opened the service gate at the rear of the cul-de-sac. At 12 minutes past midnight, the fire started at the back corner of the house at 1 Cedar Lane in the eave above the garage where a rotted fence post had once been replaced by a man on his knees on a Saturday morning in July. The camera above the front door recorded all of it and recorded nothing. Its lens covered the porch, the steps, and 11 feet of walkway, because that is what a man buys a doorbell camera for, and the person who came that night came over the back fence and up the far side of the garage and never crossed a single foot of that frame. What the footage held when it was pulled from the cloud 2 weeks later was the porch ceiling at 12 minutes past midnight and the color of the light on it changing from the flat blue of a security bulb to something warmer, and then something moving. Diane Whitmore was not on Cedar Lane. She was at the Fairfield County Children's Hospital benefit downtown in a green dress at table 11, and she was photographed 4 times between 10 and midnight by an event photographer whose camera stamped every file. She spoke to the deputy mayor. She spoke to a bank president. 40 people could place her in that ballroom, and every one of them would have said without hesitation that she had been perfectly lovely. At 1 in the morning, she stepped outside to take a call from her nephew, and 40 minutes later she stood at the end of her own long white driveway in a green dress and a wool coat and watched the last beam come down into the ash. She checked her watch. She went home. Marcus got the call at 4 in the morning and drove back through the dark, and there was nothing to do when he arrived except stand behind the tape and look at the shape of it. The house had not burned down so much as it had burned in. The roof was in the basement. The chimney stood. The porch he had built with his own hands was a black rectangle of nothing, and the garage and everything in the garage was gone. The gray steel filing cabinet had come through the fire as a warped shell, with its drawers fused shut, and the county's forensic technicians spent 2 days extracting what was left, which was ash in the shape of paper. 11 years of records. Every receipt, every letter, every notice, and in the second drawer, the external drive that held the photograph of each of them taken the day it arrived, moved off his phone that same night and kept nowhere else in the world. Paula Hartley came out on the 14th and found him standing at the curb. "The insurance will cover the structure," she said. Marcus told her that he was not thinking about the structure. The cleanup crew came on the 15th, and Diane watched them from her driveway with coffee in her hand, and it did not feel like triumph. It felt like exhaling. She called Holloway's counsel that afternoon and told him the corner lot's improvements had been destroyed by fire, that the owner was a public employee carrying a $40,000 assessment and no residence, and that in her professional judgment he would sell within the month. Holloway extended the closing by 10 days. She hung up and sat in her car and shook for a little while, and then she stopped shaking and went inside and made a list. The board convened on the 18th and passed a resolution establishing standards for vacant lots within the community. Debris removal timelines, mandatory grading, and a provision that any lot remaining unimproved beyond 120 days would be subject to compelled transfer at appraised value under the association's covenants. Nobody voted against it. There was no longer anyone to vote against it. The street believed it was over. Marcus Reed had lost his house, his records, and his standing, and there was a general feeling on Cedar Lane, never spoken aloud, that these things had happened to a man who had brought them on himself by being difficult. He did not go looking through the wreckage for the small camera behind the front window. He knew what fire does to a plastic device in a window frame, and he had not built anything on that camera anyway. On the 17th of March, he sat down in Paula Hartley's office above the dry cleaner and slid a single piece of paper across her desk. It was a green card, a certified mail return receipt signed and dated by a clerk at Brightwater Property Management the 4th of February. Paula looked at it and looked at him and understood it about 4 seconds before the rest of the world would have. "They kept it," she said. Marcus nodded. The letter he had mailed on the 4th of February had not been addressed only to the association whose president had put it in a drawer with her appliance warranties. It had also been served on Brightwater, a company with 900 clients, an errors and omissions policy, and a compliance officer whose entire professional existence was organized around the possibility of being asked someday under oath what she had done when a preservation demand arrived. What she had done was place a legal hold on every record associated with the Cedar Lane community on the 6th of February and suspend the automatic 30-day purge on the gate system. That system logged every key fob activation at both the main and service gates. It also fed 2 cameras mounted on the gate posts, which recorded every vehicle that entered or left the cul-de-sac and which had done so continuously, including on the night of the 12th of March. Those records did not live on Cedar Lane. They lived on a server in a data center 90 miles away owned by a company Diane Whitmore paid $1,100 a month and had never once thought about. "She'll try to delete it," Marcus said. "Her emails, the portal, whatever she can reach." He turned the green card around on the desk with one finger. "And she won't understand why it doesn't work. She doesn't own the server." It mattered, and Paula said so out loud that this had nothing to do with what he did for a living. He had not called anyone. He had not asked a favor. 5 weeks before, there was a fire. Before there was any reason to imagine one, a man who had been denied by his board, dismissed by an officer, and turned down by a court, had done the only thing still available to him, which was to write a letter and pay $4.80 to have someone sign for it. Everything that followed was built on that receipt. It took 11 days to get an order compelling production, and Brightwater did not resist it for a moment. A company under a hold is delighted to be told by a judge to hand things over. Alan Voss came out to Cedar Lane 3 times that month, and all 3 times he sat in Diane Whitmore's kitchen, and she made him coffee. He was not a cruel man. He had investigated fires for 19 years. He asked open questions and wrote down the answers. And he had learned that people who volunteer information are rarely the ones you end up charging. Diane volunteered a great deal. On the first visit, she gave him the association's citation history for the corner lot unprompted and mentioned that the owner had been under considerable financial strain. On the second, she remembered that the owner had announced his travel dates at a board meeting and offered to have the minutes sent over. On the third, unhappy with something in her own earlier account, she corrected herself about what time she had gotten home from the benefit and gave him a time that was 11 minutes later than the truth, and that she had no way of knowing would eventually be checked against a photographer's file stamps. She was not lying to him mostly. She was performing helpfulness because she believed that the most cooperative person in a room is the least suspected one. Holloway Development withdrew from the assembly on the 24th of March, 1 week before closing in a 2-paragraph letter citing material uncertainty regarding title and community governance. The broker's advance Diane had taken against that closing became in a single afternoon a debt owed to a corporation with a legal department. Nora Chandler published on the 26th. The piece was careful and dull and devastating, a 9-lot assemblage of $40,000 special assessment levied against the single holdout lot, a city inspection finding no defect in the easement that assessment was meant to repair, and a house that had burned 19 days before the closing date. Diane read it standing up. She got most of the way through it in a state of controlled fury, and then she reached the last paragraph, which noted in the flat way, "Reporters note matters of public record," that the owner of One Cedar Lane was Marcus Reed, a sitting judge of the circuit court. She read that sentence 4 times. Then she sat down at her kitchen table, and everything she had done for 8 months rearranged itself in front of her, and out of the rearrangement came an idea. She did 2 things that week, and the first was to sue Ruth Delaney. Ruth had 4 days earlier finally told Alan Voss what she had seen at the service gate at 2 in the morning, and had mentioned as well that Diane Whitmore had called her in February about her son's contracts. The complaint Diane filed accused Ruth of defamation and of tortious interference with the association's vendor relationships, sought damages of $200,000, and moved for expedited hearing on injunctive relief. Ruth was 68. She had no lawyer. She stopped sleeping. The hearing was set for the 2nd of April. What happened in that courtroom lasted less than 2 minutes, and it would be several weeks before Marcus understood how much those 2 minutes were going to cost him. The second thing Diane did, she did 3 days after that hearing at her kitchen table in a 9-page document she did not sign. It was a complaint to the State Judicial Conduct Commission, and it was better written than anything else she had produced that year, because by then she was very frightened, and fear had made her precise. It alleged that a sitting judge of the circuit court had used his office to advance a private dispute with his homeowners association, that he had caused a preservation demand to be served on a management company in a matter in which he was personally interested, that he had permitted a county fire investigation to proceed in the shadow of his position, and that on the 2nd of April he had taken the bench in a civil proceeding involving a witness in his own complaint. Every allegation in it was false in intention and accurate in fact. That is what made it so effective. She had watched him give away his only advantage in a single sentence, and she had found a way to charge him for it. What Alan Voss had on his desk by the first week of April was this. The owner of the property had increased his homeowner's coverage in the first week of February, 5 weeks before the fire. The owner had announced his absence publicly in recorded minutes and had been 3 hours away when the fire started. The owner was carrying a $40,000 assessment he had refused to pay and could not easily pay, secured by a lien with power of sale. The owner stood to receive a structure settlement substantially exceeding the assessment. On paper arranged in that order, Marcus Reed was the most obvious suspect in the file. Voss requested his financial records on the 7th of April. He was polite about it. He said it was routine. Then the association's attorney, who had been given a copy of Marcus's own submission, filed a motion challenging the second camera, the small one Marcus had mounted behind his front window, without telling anyone whose footage had been recovered from its manufacturer's cloud account. The motion argued that its field of view crossed the street and captured the driveway of 3 Cedar Lane, that it had been installed covertly during an active dispute, and that anything it recorded should be excluded. It was not a frivolous motion. Paula told him that honestly, sitting on a folding chair in the rented apartment he had moved into, and told him it might take a year to resolve and might not go their way. The commission's letter arrived on the 14th of April. It advised Judge Marcus Reed that a complaint had been docketed, that the matter would be investigated, and that pending the outcome he was suspended from the performance of judicial duties. There were forms to be returned. There was an inventory of his chambers. He handed in his robe on a Thursday afternoon to a clerk who had worked down the hall from him for 6 years and could not look at him while she signed the receipt. That evening he drove out to Cedar Lane and stood on the graded dirt where his house had been. He had lost the house in March, and he had understood the house. A house is lumber and drywall and 11 years of Saturdays, and it is insured, and it can be rebuilt by men with trucks. He had lost the cabinet, and the drive inside it, which was worse, and he had survived that too because the thing that mattered had never been in the cabinet. This was different. What they had taken now was the one thing he had spent 30 years believing was not a possession at all. He had told himself the whole way through that the record would hold, that the process would eventually arrive. And now the process had arrived and put its hand on his chest. The cruelty of it was not that he had lost a roof. It was that he had very nearly been persuaded, standing there in the dark, that he no longer had the standing to ask anyone for anything. He called Paula from the car. She started explaining the timeline for a commission response, and he cut her off, and what he said she wrote down that night because she knew she would want it later. "There are people who'll tell me to make 3 phone calls and this goes away," Marcus said, "and they'd be right. It would go away." He watched a car turn at the end of the street. "But if I win from that chair, then everything she believed about me is true, and she gets to be right forever." Ruth Delaney came to see him on the 16th of April. She came to the apartment which she had gotten the address of from Paula, and she brought a foil pan of something covered in plastic wrap, and she stood in the doorway holding it with both hands. She told him she had known. Not everything, she said, not the fire, never the fire. But she had known about the citations, and she had seen the boy at the gate with her own eyes at 2 in the morning, and she had known in February when Diane called her about Danny's contracts exactly what that call had been. "I stayed quiet because I thought nobody would believe an old woman," Ruth said. "And I have been telling myself that for 8 months, and it was true enough to live with." She set the pan down on the counter. "Then they didn't believe you either, and you're a judge." Her hands were unsteady on the strap of her purse. "So, what exactly was I keeping quiet for?" She took out her phone. She explained that Marbles had gotten out again on the night of the 12th of March and gotten onto the carport at the side of her house, and that she had gone out in her nightgown to film him because Danny never believed her about the cat. The video was 40 seconds long. The file said 11:50 at night, the 12th of March. For the first 30 seconds, it was an old woman's voice saying a cat's name and a gray shape on a carport roof and the shaking beam of a porch light. Then she turned, following the cat, and for 6 seconds the camera swung across the mouth of the cul-de-sac and the service gate behind it, and in that frame, parked with its lights off in the turnaround, was a pickup truck. Ruth Delaney's 40-second video did not make Marcus feel triumphant. It made him careful. He copied nothing himself. He drove her downtown the next morning and sat in the waiting area while she gave the phone to an investigator from the district attorney's office who imaged the device in her presence and gave her a receipt. Marcus never touched it. He did not want a single link in the chain to run through his hands. Then he did 3 things, and none of them required being a judge. The first was a written response to the Judicial Conduct Commission, 41 pages prepared by Paula Hartley and signed by him. It did not argue that the complaint was unfair. It answered every allegation with a document in order, and where a document no longer existed, it said so plainly. He attached the citation appeal. He attached the denial. He attached the police report with the officer's notation and the order denying his petition for a restraining order, and the minutes of the February meeting in which he had asked the board for 14 days. The second was a letter to the district attorney requesting that her office assume the file in its entirety and stating that he would make himself available for interview under oath without counsel present if she preferred. The third was the one Paula argued with him about for 2 hours. He filed a written undertaking that he would not communicate with any judge, clerk, prosecutor, or investigator connected to any proceeding arising out of Cedar Lane on any subject for any reason, and asked that it be entered on the record. It gave away every advantage his position could have bought him. It meant he would learn what was happening in his own case the way a stranger would. Paula told him that no one would have faulted him for making a single phone call. Marcus said that he was aware of that, and that this was the point. Alan Voss got the financial records on the 18th of April, all of them unredacted, sent by Marcus's own accountant without a subpoena. Voss spent 9 days building the arson for profit theory to its full height, and then Brightwater's production landed on his desk and the whole structure came down in an afternoon. What was in that production was the reason a fire investigator would later describe the case at a training seminar as the cleanest he had ever worked. The key fob access log for the Cedar Lane service gate recorded fob number 224 issued to T. Whitmore at 11:47 on the night of the 12th of March. The gate camera recorded a pickup truck entering the cul-de-sac at 11:48 and leaving it 26 minutes later at 14 minutes past midnight, 2 minutes after the first ignition in the eave above the garage. Ruth Delaney's cat video shot at 11:50 from a carport 2 houses down showed the same truck parked with its lights off in the turnaround at an angle that gave the plate. The cell record showed a 47-second call from Diane Whitmore's phone to Tyler Whitmore's phone at 11:41. And Brightwater's compliance officer, in a deposition that ran 90 minutes and produced no drama whatsoever, testified that on the 6th of February, she had placed a litigation hold on all Cedar Lane records and suspended the 30-day purge cycle on the gate system in response to a certified letter, and that she had done this because it was her job. She also testified that on the 28th of March, an administrator account belonging to the association president had attempted to delete everything the system had retained since the 6th of February, and that the attempt had generated an automated preservation alert, and that the underlying data had never been at risk because clients did not have right access to the archive. That single act, undertaken in a panic by a woman who did not understand the system she paid $1,100 a month to use, turned a property dispute into a felony charge for tampering with evidence. The association drawer was the last piece, and it survived for a reason nobody had planned. The steel cabinet in the garage had come out of the fire as a fused shell, and the drive in the second drawer had gone with it, and 11 years of paper had ceased to exist in either of the 2 forms it had ever taken. But in January, before any of it, Marcus had carried 1 drawer of that cabinet into an office above a dry cleaner in a banker's box, and left it there because a lawyer had asked to read it. It was still on the floor beside Paula Hartley's desk under a coat. Inside, it was the comparison table: 14 citations against 1 Cedar Lane in 6 weeks, 19 against the other 8 houses combined, all issued by the same inspector, all signed by the same president. Inside, it was the offer letter Diane had brought to his kitchen in August. Inside it were the minutes. None of it proved arson. All of it proved motive and pattern, and 8 months of intention. Paper doesn't lie. It just waits for the right person to read it. The first of the 3 things that broke Diane Whitmore had already happened, and she had not yet understood what she had seen. On the 2nd of April, she had come to court to shut an old woman up. She had walked into that room with a $200,000 defamation complaint and a motion for expedited injunctive relief, and Ruth Delaney had sat at the defense table with no attorney and her purse in her lap, and Diane had been entirely confident because she had done the arithmetic on what a lawsuit costs a widow on a fixed income. Then the door behind the bench opened, and Marcus Reed came through it in a black robe. She had heard him say the words. She had not been able to process them at the time, and she replayed them for weeks, afterward always arriving at the same place. He recused himself. He was for perhaps 40 seconds a man with total power over the woman who had burned down his house, and he gave that power away on the record in a single sentence and walked out without looking at her. The case went to another judge who read the file in May and dismissed the complaint with prejudice, and then, on his own motion, imposed sanctions against Diane Whitmore and her counsel for the use of civil process to intimidate a witness in an active criminal investigation. Ruth Delaney never paid $1. She got a check for her costs 11 months later and framed it. The second thing happened at the preliminary hearing in July. The prosecution put up the gate footage, then the fob log, then the compliance officer's testimony about the deletion attempt on the 28th of March. Diane leaned toward her attorney and said 6 words that the courtroom microphone at the defense table picked up cleanly because defense tables have microphones, and she had spent 6 years running meetings and had never in her life learned to lower her voice. "I deleted all of it," she said. The recording was played at trial. It was the only time her own voice testified against her. The third thing was her nephew. Tyler Whitmore had been charged with first-degree arson, and the plate in Ruth Delaney's video was his, and the fob was his, and the truck on the gate camera was his, and his attorney explained to him in plain terms what 20 years meant when a person was 24. He took the agreement in August. What he gave the state was not the fire. They already had the fire. What he gave them was one detail nobody had thought to ask about. His aunt had not sent him out on the night of the 11th when Marcus left. She had made him wait a full day. She had called the hotel that Tuesday afternoon and confirmed the guest was registered. She had checked the driveway at 1 Cedar Lane twice on the 12th. And at 11:41 that night, she had called him for 47 seconds to tell him that the car was gone, and the man was 3 hours away, and only then had she told him to go. She had done it so that nobody would be inside. That was the thing that finished her, and the shape of it was almost unbearable to look at. Every act of caution she had taken to protect herself became a link in the chain that convicted her. The benefit photographs were the first. She had been at table 11 in a green dress photographed 4 times between 10 and midnight by a photographer whose camera stamped every file, and she had gone to that gala specifically so that 40 people could account for her. The prosecution never contested a second of it. They used those 4 timestamps to anchor their timeline to the minute, and against that fixed spine, the 47-second call at 11:41 stopped being a coincidence and became a scheduled instruction. The same file stamps also caught the 11 minutes she had invented for Alan Voss in her own kitchen, and a woman who adjusts a time by 11 minutes has told a jury that she knows which 11 minutes matter. The second was the report she had filed with the association's insurance carrier on the 10th of March, 48 hours before the fire, formally documenting the board's concern regarding the deteriorating and unsecured condition of the structure at 1 Cedar Lane. She had written it to make the aftermath easier. Read at trial, in sequence 2 days ahead of an ignition in the eve, it read as a man laying a tarp before he opens the paint. And the third was the waiting. She had confirmed the house was empty because she was not a murderer and had never for one moment considered herself one. The prosecutor put it to the jury in a single sentence: a person who verifies that a building is unoccupied before it burns has told you better than any witness could exactly what she knew was going to happen to that building. Diane Whitmore was not brought down by an enemy. She was brought down by the file she built herself, one careful document at a time. The one piece of evidence that never made it into the case was the small camera Marcus had mounted behind his front window on the 7th of March without telling anyone. The court granted the motion to exclude it in June. The judge found that its field of view captured a portion of a neighbor's driveway, that it had been installed covertly during an active dispute, and that the prejudice outweighed the value. It did not matter. Not one element of the state's case rested on it, and neither did anything else he had done in secret. Everything that convicted her had come from a company she had hired, a system she had paid for a gate she had installed, and a letter mailed on the 4th of February by a man who had already been told no by his board, his police department, and his court. The trial ran 9 days in October. The verdict came back on a Thursday afternoon guilty of arson in the first degree, guilty of conspiracy to commit arson, guilty of tampering with physical evidence. Tyler Whitmore was sentenced in November under the terms of his agreement to 6 years with credit for time served. Diane Whitmore was sentenced in December. The presiding judge imposed 14 years on the arson count, with the conspiracy and tampering counts to run concurrently, and ordered full restitution. Before pronouncing it, he said something that ran in Nora Chandler's paper the following week, and that Ruth Delaney cut out and kept in a kitchen drawer. He said that the court wished to be clear about one thing for the record and for the community. The defendant had not been convicted because of who her victim happened to be. She had been convicted because of the log her own gate produced the archive. Her own vendor preserved the report she herself filed with an insurance carrier 2 days before the fire and the account she herself gave to a fire investigator across 3 separate visits to her own kitchen. The court had been handed a case that the defendant had in every meaningful sense assembled and delivered. Marcus Reed sat in the 4th row of the public gallery in a gray suit with Paula Hartley beside him. He was not called. He made no statement. When it ended, he stood with everyone else and waited his turn to leave through the back doors the way members of the public do. The Judicial Conduct Commission closed its file 11 days later. The letter was 3 lines long. It advised him that the complaint had been dismissed as unsubstantiated and that he was restored to full judicial duties effective immediately. It did not contain an apology. He had not expected one, and he found reading it standing up in the kitchen of a rented apartment that he did not particularly need one either. The $40,000 assessment died in February in a hearing that took 19 minutes. Paula Hartley put one document in front of the court, and it was not anything Marcus had preserved or photographed or hidden. It was the city inspector's report on the drainage easement at the mouth of the cul-de-sac, written the previous March by a man doing his job, filed and read by nobody for 6 weeks. The easement had no defect. There had never been anything to repair. The assessment levied to repair, it was voided. The lien was released, and the resolution of the 18th of March establishing standards for vacant lots was struck along with it as having been adopted for an improper purpose. Halloway Development sued Diane Whitmore in March for the return of the broker's advance and won and collected almost none of it. The 8 families received nothing. There had never been a moment when they were going to receive anything, and some of them understood that now, and a few of them thought for a long time about what exactly they had been waiting quietly for. The insurance settlement on the structure came through in April, and in May, there were men with trucks on the graded lot, and by June, there was a foundation on it, poured on the same footprint as the old one, because Marcus had liked where the kitchen window faced. Ruth Delaney brought over a hydrangea in a plastic pot and put it in near the front steps before the steps existed. The association held its first contested election in 7 years that spring. The new board adopted a rule requiring that every citation issued in the community be published in a monthly log with the address, the date, the inspector, and the reason visible to every homeowner. It is a dull rule. It is also the only one of its kind in the county, and it exists because a man once sat at a kitchen table and counted to 14. Ruth ran unopposed for the seat she had spent 8 months being afraid to speak from. In September, Marcus Reed put the robe back on in a small room off the corridor he had walked for 11 years. The camera would have caught him from behind, adjusting the collar, nothing of his face. On a Saturday in October, he stood in front of the house that had been built on the old foundation and looked out at the street for a while. He did not say anything about winning. "A fire can take a roof," he said. "It can't take the truth if somebody's patient enough to keep it." Then he went inside, and the street was quiet, and the story closed on the stillness of it, rather than on any sound of triumph.